After the clause indicating that legitimate bills are to be paid, many attorneys will put a clause or a paragraph in the document stating that the individual who created the trust can leave a list of personal items and indicate to whom those personal items should be given. This gives the creators of the trust the ability to change that simple form without having to have the entire trust redone in any fashion. It's something they can always use themselves and make modifications to the document and initial it as the changes are made, if any are made. Then we move on to the main focus of the trust, and the main focus of the trust is to distribute assets to the persons named as beneficiaries using the percentages, if it is a percentage arrangement, or dollar amounts, which are not always recommended because using dollar amounts means that you will extinguish the assets in the order that the dollar amounts are listed. When you use percentages, the percentages apply across the board to all the assets. There can be restrictions put on the use of those funds at the same time too. Typical restrictions that you'll find, common restrictions, relate to age, that if a beneficiary is under a certain age, the money cannot be distributed fully to them until that age is reached. But it could be used for various purposes by the successor trustee and the successor trustee's discretion, such as education, such as health, possibly to purchase a home or assistance in purchasing a home, things of that type. Support is another common reason to use the funds prior to the age of distribution, but that can be a little difficult because it's possible that a beneficiary would take the position that since the trust requires they be supported, that they're not going to work. And the only method that I've found to avoid that from happening is to say the trustee will determine their ability and their willingness, the beneficiary's ability and willingness to try to support themselves before giving them any money. After that section, we have to consider the possibility that a beneficiary may not outlive you. And in that circumstance, the clause that is common in these documents is some form of continuation, such as if a child dies, his or her share would be given to his or her surviving descendants, commonly his or her children. And when those children inherit, once again, they're subject to the restrictions on age that may be in the document itself. After those major provisions, we have a lot of what I call what-if paragraphs. What if this happens? What do we do? One of the first what-ifs is a situation in which a beneficiary is incapacitated. And where we have an incapacitated beneficiary, we need to give some instructions to the successor trustee on how to protect that incapacitated beneficiary's share of the trust assets, such as possibly giving it to a guardian if a guardian exists, such as possibly giving some of the money or all of the money to a relative who may be taking care of the beneficiary. Or in a lot of cases, it's necessary for the trustee to simply hold on to the money, or the assets, I should say, in the trust, and use them for the benefit of the beneficiary who is incapacitated. I also use a Medicaid savings clause in the trust document, which is not based on statute or any other legal authority, but simply says that where we have a beneficiary who is on some form of governmental assistance, their share should be retained in the trust so that it is not used to repay or disqualify an individual who may be receiving assistance through Medicaid or Social Security disability. Admittedly, that clause could be overturned by a court, but at least it's an attempt for the successor trustee to have some authority to avoid that situation. We also have a clause that says a beneficiary who is not entitled to receive trust assets cannot use the trust as collateral by going to a bank and asking to borrow money against the trust. The trustee stands as the gatekeeper and that trustee, known as the successor trustee after your death, will prevent that from happening. The powers section of the trust agreement needs to have sufficient detail in it to make sure that the trustee is not handicapped at the time the trustee takes over for you, again, referenced as a successor trustee. So we rely on state law, depending on which state the trust is written in. In the states that I practice in, Indiana, Michigan, and Illinois, there is a trust code, and that trust code for those states does give a listing of powers for a trustee. And I often will add to that list by giving different authority that I believe is necessary and appropriate in addition to what state law provides. Another clause that we like to see in a trust is sometimes referred to as a kick-out clause. That's kick out, as if you were kicking someone out the door. And it says, if the value of the assets in the trust reaches a certain low point, such as in the trust that I do, typically $10,000, that the trust does not have to continue. This prevents the need to maintain a trust even though the funds in it are so low that it is not a wise or logical idea to keep it running. In the United States, in almost every state, including the 3 that I am licensed to practice in, Illinois, Michigan, and Indiana, a document that is a trust should contain a clause saying that it cannot be a perpetual trust. So we have a paragraph saying that the trust must end 21 years after the death of the persons named inside the document as beneficiaries, which would include the individuals who created the trust. Towards the end of the trust document, we put in some fairly simplistic things, such as the fact that an individual who is acting as a successor trustee would have authority to assist the persons who created the trust in filing income tax returns. Also, we keep language in the document that allows the trustee to put more assets in the trust, because it's possible you may become incapacitated and your person named as successor trustee, also possibly named as a beneficiary, could use a power of attorney to transfer assets to the trust itself. And the final clause in a document is one that references the law that governs the document. I prefer to use a reference to your state of residence as opposed to a specific state. That allows you some portability. For example, if an individual sets up a trust in one state and then decides to move to another state and become a resident of that state, my document says the law of the state of the person's residence will govern any questions about the document, and that provides the ability to make that document much more portable. This has been a very brief overview of what you would find as typical provisions in a revocable living trust. It's not meant to be exhaustive. This is not meant to be any legal advice. This is purely an informative overview of the things that I typically see in my practice, and it should be limited to that understanding. I hope you found this to be informative and enjoyable.